Howard Levitt is an employment lawyer with Levitt LLP in Toronto. Delighted to have you back, and as always, the questions have been flooding in for you. Thanks for coming back, Mr. Levitt. Good to see you.
Great being here. Thanks for having me.
I know you were listening to Laura, and I wanted to use that as the introduction to you and get a little bit of your take on all of this. Let's begin with the employee standpoint, because this is CBC News investigation reporting. The spike in the number of people who have formally refused to go back to work because they say conditions are dangerous. Under what circumstances can an employee refuse?
If it's dangerous. Now, the law does not accommodate anxiety. It accommodates safety. And sometimes employees, because they've been hearing for months from the government, from the federal government, stay home, it's dangerous out there, don't go to work, work from home, be safe. And all of a sudden, it's running afoul of employment law obligations, which is to return to a workplace unless it's demonstrably, objectively unsafe. But I think what's happening, I think why the numbers of the successful refusals have been so low is because there haven't been many refusals in the first place. What's happening generally is employees are working it out with their employer. Employers are saying, if it's unsafe or if there might be a risk of unsafe, because we don't want to finding that a workplace is unsafe, we'll let you stay home. So by the time it gets to the level of an actual workplace refusal, in almost every case, it's being a safe workplace.
Okay, that's good. So it's not it's a general fear of COVID is not enough. And just I'd like your thought on one of the things that Laura was also mentioning, the risks of traveling to and from work. So potentially taking public transit, that too is not sufficient to amount to a dangerous condition.
That's correct. Essentially, everyone's been saying, when I say everyone, I mean health and safety inspectors and employers are saying how you get to work is really your concern. Interestingly enough, I just tried renting a car just to see what it would cost. It's like $9 a day, including taxes right now. So employers are saying, rent a car, find another way of getting there. How you get there is not the concern of the employer. It's not the concern of the health and safety inspector. So you're right. That is not an excuse for not coming to work.
Okay, so from the employer standpoint, what is he or she obligated to provide to the workforce?
Not a prophylactically safe workplace, not a perfectly safe workplace, but a reasonably safe workplace that largely protects employees. You can't protect everybody against any potential harm, but you have to do the right things. You have to make sure people who have any COVID symptoms aren't allowed in the workplace. You have to make sure everything's sanitized daily. You have to make sure there's a proper social distancing. You have to do the things that we've been hearing about and talking about for some months now. And if you don't do that, you're going to be in some difficulty. In fact, the real concern is the employer's concern, because it could be $1 million lawsuit, a many $1 million lawsuit. If someone comes to the workplace, the employer has kept it unsafe, and they contract COVID-19 and, God forbid, die or get permanently immunocompromised. So employers, more than anyone, want to make sure no one can argue it's unsafe and no one can assert later that it's unsafe, and that they're not negligent about this, and they're very careful about this.
Let's get to a couple of questions, because, as I mentioned, they're already pouring in for you, Mr. Levitt, and some of them are specifically related to where we are in the conversation. So this is from Morgan, who writes, she works at a daycare where social distancing isn't possible. Her mother has terminal cancer and a compromised immune system, and she's living with her and is her primary care provider. In your opinion, can she get an exemption from returning to work?
In my opinion, she can. In that circumstance, where there's someone in their household that is imperiled and she can't have social distancing in her workplace, then she can get an exception. In her case, if she couldn't work it out with her employer and she had to call a health and safety inspector, she would be one of the ones that would win.
Okay, so she should try to reach out to the employer, come up with some reasonable accommodation, and then go further if that isn't able to be a set.
The employer does not want to be responsible for her mother's death. And if there's that kind of situation where there can't be social distancing, then it's a real prospect.
From New Brunswick, Brandon, if I have to take temperatures of employees as they come in through the door, as some workplaces have now mandated, does the workplace have an obligation to make the employees wear masks? Because I, Brandon, who's taking the temperatures, has to get closer than 2 meters.
Well, then the answer to that is yes, and certainly Brandon himself should be wearing a mask. But what I've seen occurring is it's put on a ledge. The employee picks it up, they put it in their own mouths, they take their temperature, they put it right down. The employee, Brandon, then would pick it up, take a look at the temperature, and then sanitize and move to the next person. They don't have to come within 2 meters.
This is from Chris, his employer wants him to come back to the office, but they've not informed him of any new measures that have been put in place to keep the office safe. I asked, and they said a generic, "We'll clean more." Do I have to go into the office?
Well, you have to have a better dialogue and ask precisely what the issues are. Then you have to go to the office if it's still ambiguous, because you don't want to be fired for abandonment or resignation, and see for yourself. If at that point it's unsafe, you discuss why it's unsafe with your employer, and you can refuse to work until an inspector from the Ministry of Labour comes and determines whether indeed it's safe. Look, it's not right for the employer not to be more explicit and clear, because that's the employer's obligation, but the employee still has to at least attempt to have that dialogue and see for himself or herself before making that decision. And as I say, at the end of the day, the Ministry of Labour inspector can come in and make a determination, and the employee does not have to work until that occurs.
This is a variation on the theme, as I mentioned. 70 years old, Joanne, writing she works in a retail setting at a resort. And as Ontario opens up, Joanne and her co-workers are seeing more visitors from Toronto. The company has safety measures, but she feels it's still impossible to physically distance, and people aren't wearing masks or distancing, and they often do not sanitize. So her husband and her brother are compromised with health issues, and her concern is for safety. Does she have any options? I would say, is this a case where she might be exempt from having to go to work, or are there other options she's interested in, maybe leave of absence with any EI support?
Well, she certainly, or CERB support more likely would apply than EI support in her case, but she certainly can have that dialogue with her employer, explain her discomfort. I find most employers, if they think there's some legitimacy to it, will say yes, because they don't want to end up getting sued for negligence at the end if they come to work and then get sick, or somebody in their household gets sick, or somebody they get in contact with gets sick. The employer could be liable for millions of dollars. But if that dialogue does not work, then they have to put on their own mask, go in, see if in fact it's actually made safe, because employers are taking many measures right now to make workplaces safe. And at the end of the day, if they still think it's not safe, the employer doesn't agree to give them a leave of absence, then call in the health and safety inspector and will make a binding determination.
Health and safety inspector. Okay, that's where it moves. Oh, you mentioned CERB. So I have a CERB question. It's a complicated one. So let's follow the bouncing ball. This is from Jack.
Okay.
Jack is the owner of a limited company and is the sole employee in the company. So it's just Jack. The ability of his company to conduct business is severely restricted due to COVID-19 restrictions at his customers' facilities. Can he, in the dual role of employee and owner, decide that the business is temporarily not viable because of COVID-19 and therefore qualify for CERB?
If his business, based on his measure of accounting that he's always used for net income, goes down to less than $1,000 every 4 weeks because of COVID-19, and it was above that before, then he absolutely does qualify for CERB.
We always have you on the hot seat with a whole range of themes, my goodness, and you always prove your worth, Mr. Levitt. Okay, here's another one about short-term disability. And this, we have to thank Paul for this one. Currently on short or long-term disability, says short/long-term disability as a result of COVID-19. Assuming he has to return to work, and then there's a second wave, which of course many of the experts are pointing to in the fall. Can he go back to short-term disability status automatically, or does he have to go through all the application process again?
Well, he does, because the thing about short-term and long-term disability is it changes from day to day. You may be disabled, then you may recover, and you're only entitled to short-term or long-term disability for the period of time they're actually disabled. So even if he's on short-term disability or LTD, the long-term disability, the insurer or the employer, depending on who's administering it, is always going to be checking to make sure the disability continues. So if he's now not disabled, and then it becomes disabled again, he's going to have to prove that yet again.
What are an employee's rights in terms of having to return to work? What assurances are they guaranteed?
They have to understand this. Apprehensive as they are, the law does not accommodate anxiety. It accommodates genuine, objective safety issues. They have the right to a safe workplace, not a perfectly safe workplace, but a reasonably safe workplace. And if they have any concerns, they should be speaking to their employer first and saying, here's what it was like before. This wouldn't be safe to me. What have you done in terms of social distancing? What have you done in terms of cleanliness? What have you done in terms of maximum capacity in receptions and boardrooms and kitchens? And If they're not satisfied, they should express those concerns and continue the dialogue. If they're still not satisfied, ask for an unpaid leave of absence. And if they're still not satisfied, the employer says, no, I want you to come to work. I'm not prepared to let you work from home and pay it there. They don't want an unpaid leave of absence. Then the last recourse is to call the Ministry of Labour and bring in an occupational health and safety inspector who will either say it's safe, and if the employee doesn't work at that point, they've resigned. It's unsafe, they can stay home. Or it's not safe, but if the employer does these 4 things, it will be safe, at which point the employer has to do it. While all this is going on, the employee does not have to work.
And does this vary, or are there any differences if it's a unionized or non-union shop, Mr. Levitt?
Well, if it's a unionized shop, and these regulations are the same across the country, if it's a unionized shop, the union will do your fighting for you. But other than that, it's the same thing.
And what about, again, just speak to this from the employer's perspective, because we're hearing from employees mostly this morning saying that they don't feel in many cases they've had sufficient information, for example, from their employer. Well, we're cleaning more is what one viewer already has told us. So from the employer's perspective, you've made it clear they want to avoid any nasty situations. What are they obliged to do?
Well, they have to avoid it, because if they don't, they could get sued for millions of dollars if they're careless, negligent, and people get sick in their workplace, or they don't get sick, noticeably sick, but they carry it to an immunocompromised family member or even a third party. So they've got real risks. What they have to do is go through carefully every aspect of the workplace and see what is potentially unsafe and fix it. And make sure it's safe, and post notices, and have sanitization stations, and insist on social distancing, and supply masks, and have rules about how many seats are in the boardroom, remove the other chairs, how many people can be in the lunchroom at the same time, maybe stagger their hours. It's really contextualized. Every single workplace should have different rules depending on what makes that workplace safe.
We had a question from Brandon in New Brunswick, and I think it's worth bringing up again and then pushing it forward a little bit. He was wondering, he has to take the temperature of his fellow employees as they arrive at work, and he's wondering if they must be obliged then to wear masks because he's in closer proximity than 2 meters. In terms of mandatory mask wearing, what are the rules for a workplace? Mandatory mask wearing, I think, as the same things. You know, are you allowed to take your employees' temperature to make sure? What kinds of things are allowable and what kinds of things are advisable?
Well, it's certainly permissible to take your employee's temperature upon entering the office, and I think it's even advisable, although not legally required. Even within the office, in any office, at my own office, we have a situation, a system where people put documents down, steps away, other people pick up the documents, we then sanitize the facility, the surface that's been on, and no one ever gets within 6 feet of each other. That's what employers have to do right now.
Mr. Levitt, I'm always struck by the number of questions we get when you're on our program. Obviously, back to work and these workplace issues, it's all new still as we navigate this COVID-19. So I hope you'll come back when we have occasion to come back because we really appreciate your expertise.
Thanks for having me. Happy to.